me on this political journey that I'm on today is something that I'll never, ever forget. I want to just wish John Glenn, our former colleague, a happy birthday and thanks again and again for all the service that he's given to this great nation. He has really made America a better place, and I'm honored to have been one of his colleagues, and I yield the floor.
Mr. President.
Senator from Iowa.
The Supreme Court earlier this month issued a very important decision, a decision that bothers me, a decision that I think shows that dissenters in this decision are really judicial activists. It is important not only on the merits of the case, but because it shows how this country is only one vote away from an unprecedented judicial activism. The Obama administration is encouraging this judicial activism. The Obama administration is taking legal positions that threaten the role of Congress as a co-equal branch of our government. Those positions challenge the separation of powers that is designed to protect the freedom of Americans and even the right of people to govern themselves, which is the basis of representative government and the purpose of the Congress. The United States happens to be a party to the Vienna Convention on Consular Relations. This treaty gives rights to the citizens of countries who are parties to that treaty to have access to their country's consular officials if they are arrested abroad. There are some foreign nationals in this country who were sentenced to death without those rights being respected. All of these death sentences appear to be valid under the American Constitution. Now, the story is complicated, but in 2008, the Supreme Court ruled that failure to comply with the treaty was not an obstacle to the execution of a foreign national who had been sentenced to death. This was the case even if the President ordered a state to allow the criminal to challenge his sentence in light of the treaty, and even if the criminal obtained a judgment from the International Court of Justice that his conviction violated international law. The court said that Congress could pass legislation to make the treaty apply to people on death row who had not received consular access. We in the Congress have never passed such a law. Now to the Supreme Court case that concerns me in light of this background on the Consular Relations Treaty. In 1994, Humberto Leal Garcia, a Mexican national, kidnapped a 16-year-old girl, raped her, and bludgeoned her to death. He did not ask for access to the Mexican consul, and he did not receive access. He did not challenge his failure to receive consular access during his trial. Only after he brought state habeas corpus litigation did he raise this claim. And then, even then, he did not raise consular notification as an issue in his first habeas corpus position. Mr. Leal did obtain a ruling from the International Court of Justice that his conviction and sentence were obtained in violation of international law. The International Court of Justice ordered that he was entitled under international law to receive another review of his conviction and sentence, regardless of whether habeas law allowed him to raise such an issue. But that ruling is obviously not binding on American courts, as no country in the world, even including the country of Mexico, enforces International Court of Justice rulings as part of its domestic law. As his execution date approached, Mr. Leal sought a stay in the Supreme Court. Since Mr. Leal received a fair trial under American law, and there was no question concerning his guilt, his request should have been rejected and rejected unanimously. But that is not what happened. He was executed, but the Supreme Court's ruling was shockingly close, 5-4. The Department of Justice, through the Solicitor General, Donna Verrilli, asked the Supreme Court to grant the stay. Its brief was truly astonishing. It did not argue that there was any doubt about Mr. Leal was guilty. It did not say that Mr. Leal had been harmed in any way by the Vienna Convention violation. It cited no case that provided an example where a stay had been issued in similar circumstances. It raised no arguments for the stay that were based on American law, because American law did not support a stay. Instead, the Department of Justice relied on international law and made policy arguments. It argued that Mr. Leal's execution would create negative effects on America's international relations. It argued that his execution would violate our international legal obligations. And it argued that the mere introduction of legislation, now understand this, just introducing a bill and at the same time having the support of the Obama administration, should allow the court to issue a stay to preserve its jurisdiction if time were given to allow the bill to be enacted. This is a position that worries me and threatens the role of Congress as a co-equal branch of government. Everyone knows bills are not laws. Bills are what we introduce. If we pass bills, they become law. The Founding Fathers made it very difficult to enact laws. There are two houses of Congress, and each has to pass the same version of the bill, and the President has to sign that bill, or a supermajority of both houses must override a veto. This was done to protect the rights of the American people. Only if a bill passes through a specified process can a bill become a law. A court following the rule of law can only enforce what actually becomes a law. There may be times when an agency might pay attention to a bill that is introduced, but that's an agency. In the case of courts, a court should only apply what has actually become law. In other words, a bill passing both houses of Congress, signed by the President. Not just pay attention to a bill that's been introduced. The Solicitor General brief relied on a bill, not a law. The name of the bill is the Consular Notification Compliance Act. That bill would retroactively allow prisoners on death row whose Vienna Convention rights were violated yet another bite at the apple. If the bill passed, they would be able to delay their death sentences, lawful sentences that are lawful under American law, with another round of judicial review for compliance with what? International law. Although the bill is strongly supported by the Obama administration, it has not passed. So it is not law. It is just a bill. Now, it's going to have a hearing soon, but it's not scheduled to be placed on the committee agenda for markup. It is clear that there is no chance that this Congress would pass a law that retroactively allowed foreign nationals who face lawful death penalties another round of judicial review based upon the Vienna Convention. Congress simply will not pass a bill that gives federal judges another opportunity to display their dislikes of the death penalty by delaying cases for no good reason. Only Congress can legislate. But the Obama administration argued in the court that the Supreme Court should grant a stay even though Congress has not legislated, simply because the executive branch strongly supported the bill, which theoretically, but only theoretically, could pass at some future time. Now, you know what disturbs me? 4 justices agreed with this outlandish position. There is absolutely no precedent for the position. These dissenters accepted an Obama position that was made out of whole cloth. When courts rule based on law, we have the rule of law. When they rule based upon policy preferences, we have judicial activism, not the rule of law. The Obama administration asked for a stay based upon policy preferences, based on international law, and based on that administration's view that a bill that it supports takes overwhelming precedence over a considered decision of Congress not to pass that legislation. 4 justices, just one short of a majority, were willing to disregard American law in favor of international law. Also in favor of policy implications, and also based just upon a bill being introduced in Congress. This is not only inconsistent with the rule of law, it is a threat to American democracy. How extreme. The American people, through their elected representatives, have enacted the death penalty and established limits on habeas corpus petitions that impede executions. The people's representatives, those of us here in the Congress, also declined to enact a bill to implement the Vienna Convention. Notwithstanding that decision of the people's representatives, this administration and 4 justices would have used an unpassed bill to delay a death sentence. How extreme. They would have had the courts not allow the preferences of the American people as expressed through their elected representatives, but instead their own policy preferences. How extreme. But under our system of government, the results of the democratic process are entitled to prevail unless the Constitution, and only the Constitution, clearly provides otherwise. The position of the Obama administration and the 4 dissenting justices also is harmful to American democracy in yet another way. If the American people dislike what Congress is doing, you know, it's very simple. In the next election, elect new representatives and senators. They can ask that federal judicial nominees be stopped, or that laws be passed that overturn judicial decisions made under federal law. But what are the American people to do if judges make decisions based on the views of foreign governments and international tribunals that are contrary to our very own law? What if judicial rulings are designed to enforce decisions of the International Court of Justice, rulings that are not binding as federal law? Americans cannot influence the views of foreign governments, or Americans can't influence the rulings of international tribunals. Had the Obama administration and the 4 dissenting justices prevailed, the American people would have lost a part of the right to govern themselves. That right would have been replaced with obedience without recourse to foreign powers over whom our people exercise no voice. That is not the system that the Founding Fathers bequeathed us. The question whether courts should apply American law or foreign law is of great concern to me and to other members of the Judiciary Committee, and maybe to a lot of senators who aren't on that committee. But those of us on the committee have thought about this specific question long before this recent Layhall case that has come, I guess, within the last 3 weeks. And I have asked judicial and administration nominees about these very issues at their confirmation hearings. For instance, just a few months ago, I posed a question to the nominee for Solicitor General, Mr. Verrilli, about an amicus brief that he had filed on behalf of foreign nationals who had been sentenced to death. In that brief, Mr. Verrilli argued not that the prisoner's constitutional rights had been violated, but that, quote, "It is in the interest of the United States and the world community that the legal standards of the United States should reflect and be informed by international human rights," end of quote. I asked Mr. Verrilli if, were he confirmed, whether there were any circumstances in which he would argue before the Supreme Court in a death penalty case that the courts be, quote, "informed by international rights," end of quote. He responded, and I quote, "I will adhere to the view that foreign law, including international human rights law, has no authoritative force in interpreting the Constitution and laws of the United States except in those rare instances where federal statutes incorporate or make international and/or foreign court decisions binding legal authority," end of quote. Responding to my questions on differences between international human rights and our own constitutional rights, Mr. Verrilli states, quote, "International human rights are set forth in international treaties, conventions, and customary international law. They are not binding or enforceable in the United States unless Congress has made them so," end of quote. The Layhall case does not involve a federal statute of the type Mr. Verrilli cited, nor does it concern any international standards binding and enforceable in the United States because Congress made them so. I believe that Mr. Verrilli's brief as Solicitor General is very inconsistent with what he related during his confirmation. The brief relied on international human rights, and its only reference to American law was this bill that I've referred to, not a law, which bill under our constitutional system is as different from a law as night is from day. I would also note that Mr. Verrilli stated during his confirmation, quote, "If the Attorney General or the President directed that I take a position, one that I believe to be an indefensible view of the law, I would not lend my name or that of the Office of Solicitor General to carrying out the order, and I would certainly resign rather than carrying out the order," end of quote. Mr. Verrilli obviously does not believe that reliance solely on international law and a bill is an indefensible view of the law. I disagree with him on that point. Similarly, during her confirmation hearing, Justice Sotomayor was asked about the application of foreign or American law, and she was one of these dissenters. She stated, quote, "I do not believe that foreign law should be used to determine the results under constitutional law or American law, except where American law directs," end of quote. In the Layhall case, foreign law should not have been used to resolve the case because American law did not direct that foreign law apply. And when Justice Kagan appeared for her confirmation hearing, she stated that in decided cases, quote, "You're looking at law all the way down, not your political preferences, not your personal preferences," end of quote. However, the law in the Layhall case is clear. Executive branch policy arguments and unenacted bills are not law. I'm not saying that the Solicitor General or these justices who dissented lied at their confirmation hearings or made a mockery of the confirmation process, but Judiciary Committee members foresaw cases like Leal and asked the nominees to address the role of foreign law in constitutional cases. I believe, although they do not, that what these individuals wrote in the Leal case is inconsistent with what they said at that time of their confirmation. Finally, one of these issues could arise again in a different legal context. Like the death penalty cases, there is ongoing litigation challenging the constitutionality of the Defense of Marriage Act. And like the death penalty cases, the Defense of Marriage Act is subject of a bill. The particular bill, called the Respect for Marriage Act, notwithstanding its Orwellian name, would repeal the Defense of Marriage Act. The Department of Justice has already decided only not to defend the Defense of Marriage Act, but now argues that the Defense of Marriage Act is unconstitutional. The Department, in light of the Leal brief, may be considering making the implausible argument that the court should strike down the Defense of Marriage Act simply because a bill has been introduced to repeal it, the same argument used in the Leal case before the Supreme Court. It might well argue that the introduction of a bill that is strongly supported by the administration is enough to lead courts to believe that Congress has already repealed the law anyway. So why not have the courts simply declare the law unconstitutional? The Department should not make such an argument, and I can tell the courts that, like the bill to make the Vienna Convention apply retroactively to convicted criminal defendants who face the death penalty, this Congress will not, and I repeat, will not, pass the Respect for Marriage Act, and courts should not consider its introduction in resolving DOMA's constitutionality. Mr. President, obviously I'm disappointed that the Obama administration has advanced policy arguments rather than legal arguments in the Supreme Court, and how ridiculous it is to try to convince the Supreme Court that just because a bill is introduced, they ought to make a decision based upon that bill being introduced. In the absence of arguments based on American law, it should not have asked the court to rule based on policy. Rather, it should have either argued based on American law, even if American law did not conform to its view of desirable policy, or it should have declined to participate in the case. And I'm also disappointed that 4 Supreme Court justices voted to advance their views of policy rather than the law, which is the essence of judicial activism. We were, or you could say we're only one vote away from a Supreme Court majority that would have applied policy preferences in favor of international law rather than American constitutional law. We were only one vote away from the Supreme Court majority that would have usurped the separation of powers by considering a bill to be the same as a law that Congress passed. And we were only one vote away from a Supreme Court majority that would have applied the ruling of international law, that would have applied the ruling of an international tribunal over which Americans have no say, rather than in a body like this Congress of the United States that is representative of and answers only to the American people. I yield the floor. Suggest the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
Without objection.
I ask unanimous consent the Senate proceed to period of morning business and is allowed to speak for up to 10 minutes each.
Without objection.
I now ask we move to S. Con. Res. 25.
The clerk will report.
S. Con. Res. 25, welcoming the independence of the Republic of South Sudan and so forth.
Without objection, proceeding to the measure.
I ask unanimous consent the concurrent resolution be agreed to, the preamble be agreed to, the motion reconsidered be laid on the table. There be no intervening action or debate, and if there are statements relating to this matter, they be placed in the record at the appropriate place as if read.
Without objection.
I now ask unanimous consent that when the Senate completes its business day, it adjourn until tomorrow morning, July 19th at 10 a.m. Following the prayer and the pledge, journal proceedings be approved to date. The morning hour be deemed expired, and the time for the two leaders be reserved for use later in the day.
Without objection.
That following any leader remarks, Mr. President, the Senate be in a period of morning business for up to 2 hours. The senators permitted to speak for up to 10 minutes each, with the time equally divided and controlled between the two leaders or the designees, with the majority and the Republicans controlling alternating 3-minute blocks, with the Republicans controlling the first block. And then the following morning business, Senate resumed consideration of H.R. 2055, the Military Construction, Veterans Affairs, and Related Agencies Appropriation Bill. And further, Mr. President, the Senate recessed from 12:30 to 2:15 to allow for the weekly caucus meetings.
Without objection.
President, we're continuing to work on Senator Johnson's Military Construction Appropriations Bill. The Senate will be notified when votes are scheduled on that matter. If there's no further business to come before the Senate, I ask that we adjourn under the previous order.
The Senate stands adjourned until 10 a.m. tomorrow morning.
The Senate continued debate today on 2012 military construction and Veterans Affairs spending and approved the nomination of J. Paul